Hello, and we're just about to go into the second plenary. This will be facilitated or chaired by Matthew Smerdon from the Civil Justice Council, also from the Legal Education Foundation, about whom we've heard considerably already, as with his co-facilitator, Dr. Natalie, Byrom. They'll introduce experts, both judicial and external. When I just mentioned experts who are judicial, can I draw attention to the fact that among the audience today, we have 50 judges at every judicial level, including obviously the outgoing and incoming MR, but also including the senior president of tribunals. Without further ado, over to Matthew and Natalie to lead this session. Thank you.
Many thanks for joining this session. Welcome to you all. We're going to focus our time this morning in this slot of the conference on the evidence base, asking the question, what's being done on data and what needs to happen? Now, just by way of brief introduction, I'll say a few words and introduce our four terrific speakers. As the MR set out in his address earlier, the critical importance of data in the civil justice system has been a real focus of concern for the CJC over our recent work. There are two CJC-led inquiries that the MR mentioned, one into the experience of vulnerable people in the civil courts, the other on the use of antisocial behaviour injunctions, both of which included the striking phrase data desert. And that hampered the work that those groups were trying to do to understand the issues that were being faced and to make improvements. The absence of data also meant that those in charge of the courts and tribunal system went into COVID-19 without key information that would have really helped with planning responses and capturing lessons. Now, the statement, the commitment that the MR outlined earlier in his opening address is extremely welcome. And in this session, what we're going to do is hear from four terrific contributors who are going to illustrate why data is so important to design and the review of policies and systems, but also crucially some experts' input on how to do that. They'll be drawing on practical experience as well as research in the justice system and beyond. So to just say a few words about our four panelists, Dr. Natalie Byrom is my colleague at the Legal Education Foundation. In 2019, Natalie was seconded by the foundation to HMCTS to support its work on evaluating the impact of the online courts programme. That work was published at the end of 2019 in a report called Digital Justice. And since then, Natalie's continued to work with HMCTS and MOJ, as well as jurisdictions in other parts of the world, on taking this important agenda forward. And also, as mentioned earlier, this year, she's also carried out two major studies looking at how the civil justice system and the tribunal system responded under COVID. Secondly, we have His Honour Judge Barry Cotter QC. Barry is a senior circuit judge and the designated civil judge managing the Avon, Somerset and Gloucestershire region, has done so since 2010. He's also a member of the Civil Justice Council and the Judicial Engagement Team, and is working with HMCTS on reform of the justice system. And it's Barry's work, which you've heard mentioned a number of times already, the two CJC studies that he led. And he will share some of his experience as a frontline judge on grappling with the challenges of data gaps. Adafi Onerhime is a data specialist, consultant, speaker and writer with more than 20 years experience of making impact with data. She's a leading voice on data strategy and data standards, and in the course of her work has led projects to make data more valued and more valuable with a nice motto: data, design, culture. And she's delivered that in a number of different sectors and contexts, most recently as head of data for effective development at the Foreign, Commonwealth and Development Office. And then finally, Professor Betsy Stanko, OBE. She is an external advisor to the Ministry of Justice led Data First project. This is a project which is aiming to improve the data available for research in the justice system space. Professor Stanko was also chair of the MOJ's Data Evidence and Science Board and has held various roles within the Metropolitan Police, where she focused on harnessing routinely collected information as intelligence to analyse, map and anticipate problems and suggest solutions. She was also formerly Head of Evidence and Insight at the Mayor's Office for Policing and Crime, and in 2014 was awarded an OBE for services to policing. So that's who you're going to hear from. Natalie, if I can turn to you first. At last year's National Forum, you presented the findings of your report, Digital Justice, which was commissioned by HMCTS. Could you briefly recap on the findings of that work and its key recommendations?
Of course, Matthew. So just to say, the Digital Justice Report, although it was written by me, it was developed in consultation with over 60 global experts in the field of access to justice, data, online dispute resolution and digital transformation. And I think the important thing to say about the report is that taken as a whole, the 29 recommendations set out an immediately implementable blueprint for improving the data we have available to us about users of the justice system, including protected characteristics, and what happens to people when they access and journey through the justice system. It recommended and set out in some detail and the data points that should be captured to improve our understanding of the justice system, improve how it works, and the data that's needed to assist the judiciary in their functions, and to support innovation in the design and delivery of both justice system processes like online courts and reform, but also critically to inform the design and evaluation of legal support services for individuals without means. I guess the second critical area for the report was it recommended vital safeguards for how accumulated information should be used and to ensure that we protect the privacy of court users, and also to ensure that the independence of the judiciary continues to be upheld as we moved into a more sort of data-driven justice system. Key to this recommendation was the recommendation to create a senior data governance panel, which for the first time would bring together senior judiciary policymakers and civil society experts recruited through open competition to take decisions about the appropriate use of justice system data and to ensure that we bring public confidence and public trust with us when we're talking about using data in the justice system.
Thanks, Natalie. Thanks very much, Natalie. What progress has been made, do you think, over this last year in delivering the recommendations of your report?
So in October, nearly a year, well, actually just over exactly a year on from when we submitted the report to HMCTS, we finally received a formal response which accepted many of our recommendations. And of course, like, this is really encouraging news and we were really happy to receive it. But progress in implementing what has been recommended has been extremely slow. And we've still got no commitment on timeframes and no commitment on funding. And I think what's interesting when people are looking through the response that HMCTS gave us, and what's important to know is that much of the work that's been described in the response has been funded by research councils, and indeed delivery of some of the most critical commitments around data governance will be funded through a partnership between the Legal Education Foundation and the Economic and Social Research Council. Now, I guess everyone's aware of the context that we're in terms of press government budgets. So you might well want to say, well, why does it matter? Why does it matter that this work's only being delivered on soft funding? With the greatest of respect, it matters because relying on soft funding to deliver this work shows that the people in charge of the court service still do not get it. Data is not a nice to have. It's not an optional extra. It's vital to running an effective modern service. And I mean, I guess I would just put it in this way. Can you imagine trying to run a hospital without understanding what makes your patients sick or how many doctors you have working at a given time? And this is the position that we're at at present in the justice system, and the lack of urgency in addressing it, despite the findings of successive reports, it's frankly astonishing. And I suppose the other thing that I would say is, much has been said, and rightly said, about the role of our civil justice system in promoting UK PLC and supporting economic recovery. I failed to think of a single business that would seek to run or innovate without having basic data about its customers, basic data about the people who work within it. And I think addressing this and really sort of getting a grip on the vanishing timeframe that we have to implement this stuff is really important.
Thanks, Natalie. And as we've heard a number of times across the morning already, responding to COVID-19 led to a rapid acceleration in the use of technology, in particular remote hearings. And that led to some describing this period as a great experiment in remote justice. What do you think we've learned?
Well, I have to say, I do really love, because I'm sure Professor Stanko and the other academics in the audience will back me up on this. It's only an experiment if you have a hypothesis and you collect data to test that hypothesis. And what I have to say is, in this regard, we have failed. We don't know how many judges sat in the civil court since COVID began. We don't know how many trials took place in the civil court. And this is really, really concerning. It's not an experiment if you don't collect the data to understand what happened. The MR was very kind about the rapid review that I conducted with an academic advisory panel over the summer. And I suppose the things that we did learn from that, thinking about the perspective of the people in the audience, is what was striking was that issues with the technology were experienced in nearly half of the cases, the 400 cases that we captured data on. And that's in spite of the fact that we're sort of 4 years into a £1 billion programme of digital court reform, because respondents told us that a lot of the issues that were experienced were due to issues with the technology that was provided to judges. And a further finding that I think bears and this sort of illustrates why we need better data, is in the context of recovery, which is going to be highly dependent on hybrid hearings and the use of remote hearings, is that actually conducting hearings remotely took longer. That was something that respondents told us. And unless we have good data to kind of model how long hearings take, how much it costs to support them, we're really in trouble when we think about how do we plan our way out of recovery and back into normal service if that ever resumes. I guess for me, though, the most sort of critical gap that we have in our understanding of remote hearings is around how people who use the courts have felt about their experience, what it's done to their perceptions of justice and what it's done to their ability to access justice. I mean, I wrote in a column in the Law Society Gazette a couple of weeks about the experience of an 88-year-old man who was been in his home for 46 years, wanted to present a defence to an eviction notice that had been ordered, and because he didn't have access to an email account, he was unable to even indicate that he wanted to be present at his court hearing. Now, because we don't have data on who is in the system, we don't know how many people have been affected in the way that he was. And I've read this before, but I think I am going to read it again because it illustrates a critical point. In the rapid review of civil justice, we did pick up a response from a litigant in person who'd been involved in a hearing, and this is what she had to say about her experience. I've never felt so stressed in my life. We'd already been put in a situation with the COVID as it was. I was losing my job. Then I had a court case via a phone call, which I found humiliating because I wasn't really given a chance to explain. I didn't understand the words as I'm not that clever. Then there was a pause. And then I was told it was my time to speak, and I tried to explain, then someone else spoke and they spoke over each other. I was so confused. I asked if they could explain it in a simple, plain language of speech. Then I heard one person say how I'd ignored all the correspondence. So I said, no, I didn't ignore it. A thing to which I was told quite sternly, do not interrupt me. I felt stupid and very upset. So I listened very quietly to the end. The hearing was then closed and I got off the phone very, very distressed. Now, this is not an experience that, anyone involved in the delivery of the justice system wants people to have. But I think it really illustrates that when you're making a choice not to collect data, it's not a choice about numbers. It's not a choice. At its heart, it's a choice about whose voices hear and whose voices we choose to ignore. And I would really caution that ignoring the views and experiences of the people who use the justice system is a really, really bad thing.
Thanks, Natalie. That's great. I'm going to ask Barry to come in now, but actually I think I invite all the members of the panel onto the stage, as it were. Barry, I shall wait until I can see you on screen. Here we are. Lovely. Barry, you've led 2 inquiries this year on behalf of the Civil Justice Council. As I say, both reports contained this striking phrase, data deserts, to describe what you encountered in trying to do that work. Could you explain a bit more about what you meant by this and illustrate the implications of those data deserts for your work? Then it would be really good to hear some of the key findings from the 2 inquiries and how better data would have helped you in developing the recommendations. And I think sort of finally, thinking a bit more broadly, how you as a frontline judge would find the improvement of data would really help you in your work and in your role. Thanks, Barry. Over to you.
Well, good morning. Well, the Civil Justice Council produced 2 reports this year. The first one in February, just before the pandemic took hold, into vulnerable parties and witnesses in the civil justice system. The second in October into antisocial behaviour and the civil courts. Both analysed areas of concern where the council felt that we needed to be doing more to provide access to justice and support for the vulnerable and to ensure fair hearings. There were 2 different, but both of them were surprised to find at the outset that there was little, if any, data retained on the central issues that they were investigating. They encountered what we described as data deserts. So what do we mean by that phrase? Well, taking first the working party considering vulnerability, we found that there was no data as to the number of vulnerable parties or witnesses, or people who perceive themselves as such, who use the justice system. Further, there was no data as to any steps taken to assist them. As a result, there was no ability to access the extent to which the civil justice system was assisting or failing court users or any identified issues. It was very surprising to us that whereas the private sector, as Natalie has outlined, uses models based on data to better provide service, the civil justice system did not appear to be doing so in any strategic fashion in the areas that we were looking at. We recommended that data needed to be captured, parties needed to be in a position to indicate on claims forms or directions questionnaires the various documentation that parties provide during the course of a claim, whether there was an issue in relation to vulnerability, or indeed whether they thought another party had issues with vulnerability or a witness, to allow basic data to be captured. So the first minimum step was to access data so that we knew the extent of vulnerability. The second step was to actually then ask those who consider themselves to be vulnerable what their experiences of the litigation process were. Did they face hurdles? Did they feel that they had access to a proper and fair hearing? But only when you've identified people can you properly then focus the second step. We also found that there was no data on the availability and use of facilities. Taking simple examples, are our buildings and equipment up to the necessary standard to allow people to use them? Many are old. On my region, I have buildings which do not have wheelchair access to many of the courtrooms. There are often too few conference rooms for those who are attending court. Perhaps those who are fearful or have other issues which mean they need a safe and quiet space before they go through the ordeal for them of a hearing, do we have other facilities available to allow people to give best evidence? There's no data to match our facilities with the need. As I've said, we found that we didn't have any data on what the need was. So we didn't have proper data about the demand or the supply. The data landscape in relation to antisocial behaviour was even more starkly barren. The Working Party was confronted with a position whereby the 2014 Act, in effect, moved the control of antisocial behaviour wholesale from the criminal courts to the civil courts. Significantly, if not ironically, that decision was taken by government on the basis of data. They had data which showed that the orders that were being made, and you remember the ASBO, I'm sure many of you, wasn't working. The breach rates were too high, and too few orders were addressing the underlying behaviour, be it mental health, be it drug abuse, be it homelessness, whatever, that was driving the antisocial behaviour. So the idea behind the 2014 legislation was that the civil courts would be in a better position to make bespoke orders addressing these underlying issues. That's what the data had told the government. But to our complete surprise, if you fast forward to when we actually came into the civil jurisdiction, no attempt was made at all to retain any data about how many orders were made, how many orders were breached, whether any positive recommendations were made for assistance to people. So there was quite literally no ability at all to assess how successful the new jurisdiction was. The council itself went about the exercise of trying to draw together some data from different sources. We had no doubt that it would not pass muster with the academics and experts who sit with me remotely on the panel today, but it was the best that we could manage. I mean, to give a specific example, our data was able to throw up a very concerning issue about the number of people who couldn't obtain any representation, although they faced a custodial sentence for breach of an order. This was very unlike the position when the cases were before the criminal courts, where legal aid and the availability of a duty solicitor meant that very few people, if they wanted assistance, were without it. We could only get a very general worrying picture. The data was and remains clearly needed. We have no figures as to positive requirements. Those are the orders trying to actually directly address the sort of behaviour by looking at the underlying cause, be it, as I said, mental health or substance abuse or homelessness. This was the very raison d'etre of the change, and there was no ability to measure it at all. So with that report, we found that we were only able to give a broad view of whether the legislation was working or not. And insofar as we were, there were very grave concerns that in fact it was representing a backward step and not a forward step. So those are the two reports. Turning to Matthew's third question, and what data would provide for me and the judges I work with, I'll briefly expand upon the words of the Master of the Rolls on the issue of data, if I may. What I'll set out is a personal view, but it is, I think, one that will reflect the views of many. What we need is data to enable us to ensure that the system works for the people who use it, that we enable full participation, that we allow people to give their best evidence, that people feel after a hearing, whether they have won, whether they have lost, that they've been able to put across their points, their voice has been heard. Those are essential elements of any justice system. But the reality is, from the perspective of litigants in person, we still know very little about what they think of the litigation process. My personal view is we need more data to be able to identify what they think. We don't know the percentage of those who are engaged in small claims or possession claims, what they think about the litigation in terms of the journey to the destination. The destination may well be the final result, but even if they won, was the victory Pyrrhic? Was it worth the journey in terms of the cost, or the delay, or the difficulty, or the stress that they experienced? We simply don't know. I think we all now get messages, be it from our GP or others, telling us, how did you rate your experience? We don't do that. We don't know a number of things, which as a judge, I think it would be very helpful indeed to know, so that we can model our system. Her Honour Judge Wall talked this morning to you about the success of her mediation service in Birmingham. But that was something that Birmingham took on its shoulders and advanced. We have very little information about why a lot of litigants, and particularly litigants in person, don't find mediation attractive. At first blush, from a judicial perspective, it may seem that it should be. But the reality is that the uptake isn't reflecting that. Why? We simply don't know. Further, in terms of the second aim of this conference, looking at technology and remote hearings, well, today we have seen some of the difficulties that can be experienced with bandwidth, but there are other issues that we're simply not investigating. As a judge, I sit here, even at home, with 2 screens. It's all very well, and I've heard from a number of people, and we'll hear in the third plenary from people who say, for example, well, anyone can access a hearing through a remote phone use. We've all got mobiles, they say. Yes, but you can't look at a document and look at a judge on a remote platform with a phone at the same time. So what do people think about that? Do they prefer telephone hearings? Or, like the example that Natalie gave, do they find that that disenfranchises them? What about the judicial perspective? What about the loss of being able to see someone, pick up body language, to be able to see whether they're stressed or distressed, or not being able to get their point across? All those things require data to be compiled. So I personally feel that if we're going to design a system that goes forward that doesn't build in elements of injustice, we need the data to be able to assess how well we're doing. It's as simple as that. Turning finally to remote hearings, on one issue, I have been surprised by the number of people who are willing and may be forced in their interaction with the courts to breach what W.C. Fields said, in that they're prepared to work with animals and children because they have no option. They don't have a quiet room that has bandwidth. They can either have a quiet room or they can have good bandwidth. They can't have both. Those stresses, those issues have a massive impact for people for whom their experience of the court may be a once-only experience and vital for many aspects of their life. I think it's great news that the MR has indicated that we're going to address data collection, and I really look forward to the progress. And as a final point, I would say that it will provide ammunition to many of you to argue for change, and that's a good thing. Thank you.
Barry, thank you very much for that. We're going to turn quickly now to Adafi, Onerhime. Adafi, you bring a wide range of experience to the questions that we're trying to tackle in this session. In particular, I would be welcome to hear from you on work that you led for the Open Data Institute on collecting data on protected characteristics, and you've done that work across government. Why is it so important to collect this information?
Thanks, Matthew. We know that the world's changing. During my research on monitoring equality in digital public services, I found that many of the public and private services we use every day are now digital. This shift is only going to accelerate as technology becomes more and more embedded in our lives. This shift affects everyone and every institution. With our world changing, it's vital that we use the right tools and the right information at the right time to reach our intended outcomes. What we do today will determine if and how we bring complicated and sometimes complex government and justice systems and institutions safely into that future. Protected characteristics are more than just classifications. They help you evidence that you are protecting individuals from unfair treatment and promoting that fair and more equal society that's at the heart of the Equality Act of 2010.
It's more about what you think the role of data in making services equitable.
So one thing just to mention first is that most people hear data, they think numbers or even categories, but it's more than numbers and categories. So if that's one thing I'd like you to take away today, is that everything, text, your case notes, your precedents, your speeches, audio, video, these are all data and they all can be used to support intended outcomes. There's an ambitious program right now on court reforms aiming to bring in new technologies and new ways, modern ways of working, so that justice can continue to be administered. But you can't do this without good data. You can't do this without good policies, and you can't do this without people having the ability to put those practices into play. Without good data, you're working in the dark. So as Barry has said, how many cases, how long, how many people do we need, how many more cases can we take on? You can't tell any of that without good data. You can't understand what's happening right now, never mind what's going to happen in the future. So without good data, artificial intelligence or AI, which is a brilliant tool when used responsibly, becomes a sticking plaster at best. At worst, AI will automate and accelerate the scale of harm, and this is not something we want to see in the justice system. Without good data, you're effectively saying, we are content to be ignorant and uncountable. Add AI to that, and all you're saying in that is that we are also content to abdicate our responsibilities to technology. And that isn't something that we want to see. There's a better way for us to do this. It doesn't have to be our reality. We can choose to do things differently. We can choose to design a justice system that is the bedrock, supported by good data, responsible automation, most importantly, people who have the capability to use the data and digital to do their work effectively. And that's everyone from clerks to the Lord Chief Justice. Everyone needs to have access to the tools, and data is one of those tools, and those tools that help you do your job properly. The justice system in England and Wales is part of a 1,000-year history of legal evolution. It has seen off trial by ordeal, trial by combat, and more. And this is an opportunity, if well managed, to design access to justice that is supported by technology rather than hamstrung by it.
Thanks, Adafi. It's been suggested that collecting data on demographic and protected characteristics is difficult, and even in some cases would argue that can potentially harm those who are asked that information and even put people off using services. Is there any evidence for this from the work that you've done across government and institutions?
So I obviously have a personal stake in this matter as someone who is of a minority ethnic group, amongst other things. So I do have a personal stake in this, but also have done professional research into this as well. And what we find is that evidence is not instinct. In 2018, the Equality and Human Rights Commission report found that 32% of businesses felt collecting ethnicity data was too intrusive, and 27% thought employees didn't want to provide that information. I just want to note the key words here are felt and thought, not evidenced or discovered. Where's the proof of this? Does anyone ask the people affected? One of the reasons people don't want to share this data is trust. So we know that building trust is necessary, and building trust can only happen by taking positive action. So what do the organizations that represent people with protected characteristics think about collecting this data? We know that what gets measured gets managed. So let's take a couple of examples. Stonewall, the organization that represents the LGBTQ+ community, share in their workplace guide how to make the most out of sexual orientation data collection. They point out that data related to sexual orientation also provides a powerful tool to measure success in eradicating homophobia from the workplace. You'll find that this view is widely adopted across the civil sector. For example, Scope, the disability equality charity in England and Wales, shared in 2018 why employers should make gathering disability data a priority. At the heart of this question is, how can you prove to the public that you serve us equally when you're ignorant about who you serve? And secondly, safety, not ignorance. This is not to minimize that there's a lack of trust in public institutions and the frustration around the lack of progress made by civic cornerstones. But the answer doesn't lie in deciding not to look into this at all. The answer lies in collecting this data safely and responsibly, giving people a choice about how to represent themselves as they identify, or even to opt out. And most importantly, you need to act on using that data to change outcomes and then show that you are doing so. Trust is built and strengthened over time by the actions that you take every day.
That's terrific, Adafi. Many thanks. We're going to turn to Professor Stanko now, but before I do that, I think the Q&A function is going to come up now. So do be posting any thoughts and questions there. Professor Stanko, your work has been widely credited with helping justice systems professionals, in particular the police, to, quote, know their own business. Could you describe some of the examples of how this has helped to improve things, firstly for frontline professionals and then also for the public?
Great. Well, thanks, and great to be here. One of the things I need to say is I arrived at the police service as a social scientist, and I was inside the firewall. Now, being inside the firewall, I realized that actually there's a lot of information that can be used in a way that a social scientist would use it, and you map that onto the way police think, and think about their work, think about crime, think about victims, offending, interventions, and basically thinking about their business. So having access to a crime record is actually having access to someone's public voice who contacts the police about something, an incident, a crime, antisocial behavior, whatever. And without knowing about that particular incident in the aggregate, how do you know what your demand is, as we suggested earlier, and what the supply is? What, can your workforce actually address the issues that are being presented to it? And in terms of doing crime prevention, crime investigation, to thinking about safety and security, you must have a strategic overview, a mission of what safety and security actually is. And you can do that by harnessing the voices of the people that contact you. That's not the only thing you use, but it is a really strong part of your evidence base. So I used crime records, downloaded them as an access database, and began to think very differently about what does crime mean to London? Now, where does it occur? I mean, why do we talk about it? We talk about high crime neighborhoods. Why? Because people in those neighborhoods are reporting things that are happening to them. Strangely, or not strangely, those are highly vulnerable neighborhoods, which, again, coexist with all kinds of deprivation. We know that already. We know that about COVID as well. So when we talk about vulnerable, one of the things I found was that people contact police because they're vulnerable. I asked once for a problem profile on vulnerability, and the analyst couldn't do it because everything was related. So it's, what kind of vulnerability is it? What do we know about protected characteristics? What do we know about the ages and ethnicities and places where people live that can help us in the texture of responding to, in a strategic way, the needs of the communities that are asking for help? Because that's what a crime report is. They're asking for help. So the more we know about it, the way I used that was to penetrate that not only in terms of frontline professionals, but at the strategic level initially, because actually those top officials needed to drive the demand that there is a strategic response to the individual responses that are given on the ground. So it cascaded through, it took me 15 years, I have to say, but it cascaded through the whole organization. I mapped it onto performance, I mapped it onto strategy, I mapped it onto resources, I mapped it onto how the employees, how do police officers feel about their own jobs, in addition to how do people feel in London about policing itself. So I had an enormous amount of information coming in, but I also then used what the business collects itself as a very clever way of beginning to present the business back to the organization itself. And that's why administrative data is so important. You need to record things, and you need to do that because it's important to know what other kind of hate crime you've got going on in London, whether it's anti-Semitic or anti-homophobic, or whether it's Islamophobic, because you don't give the same response to everybody.
And Professor Stanko, you talk about how the public feels. What were your particular observations on the role of open data in improving trust? And in particular, any observations on how it may have helped the police to build trust in the communities that they're working in?
The first thing that's important to know is that you give the same information to everyone. So the public ought to know, not that you're giving official security information out, but you're giving information about why do people call police for help in their neighborhoods. What is that? What's going on? I mean, only in the last 2 weeks have I been mounting a campaign about milk theft, antisocial behavior in my own neighborhood. And what I found out was it wasn't just my milk theft. It was actually happening systematically across the whole, multiple neighborhoods. And so it wasn't just me. There were 20 households also experiencing the same thing. Now, I would have preferred that information to have come from the police or indeed even the company, because that would have helped me protect myself from them. But there is something about enabling the public to know what's going on. So if you look at the mayor's office website, there's quite a lot, there's information about what levels of crime are they, and what's actually happening in your own neighborhoods as well, so that you can begin to engage, should you wish, with the kind of conversations about safety and security that are happening in your local areas as well as across London as a whole. So it took a long time to get the police to accept the fact that if the public saw this information, they wouldn't be inordinately frightened, but actually it enables them to, I'd rather know that a burglary in my neighborhood was about a bicycle theft in my garden shed than somebody trying to break through my front door. That information is available in crime reports. And had I been able to access that, it's much easier. You just lock your shed. So we are being asked now, for example, I'm just going to jump to the COVID example, to abide by rules. Well, we know what those rules are, but tell me what the problem is in my area. And I'll be able to actually accentuate the abiding by rules, because that will enable me to know how to apply that knowledge to my local situation. I think in terms of justice, it's really important for people to know that there are others that are being evicted. What's happened to their evictions? What are the strategies that people have used to enable them to find a way to argue that they want to stay and they can stay in their own homes? That information exists because you probably have thousands and thousands of eviction cases that can be able to tell you what works, what doesn't work, what are the problems, what are the kind of issues. Can you take that in a strategic way rather than the justice system and start working with landlords differently?
Yeah,
we can do things differently in terms of thinking about justice. I know we can do about crime because that's the kind of work I've been doing. But by using information that exists in an administrative record, improvement as that record needs, enables the business to go forward and change and think about what it does, why it does it, who it does it to, and who it does it for. And that's really important.
That's terrific, Professor Stanko. Many thanks. You started to outline there a number of lessons that you think are applicable across the wider justice system. Were there any final comments, just we got to sort of, I'm conscious of the session coming to an end, any other sort of final insights that you think, having heard the discussion today as it's been focused on civil justice, you know, what would your key advice be at this point in our journey on this?
I think, I mean, certainly in terms of urgency, timeliness, I think that there needs to be a drive to do this, and there needs to be a very, very short deadline to do it, because the longer it takes, the harder it is. My sense is that in terms of effectiveness, efficiency, use of resources, we are so missing a trick. We're so missing a trick. And my sense is that if anything would come out of this session, that the urgency to address the issues in a practical way now, get the administrative data in a state that's fit for purpose. We can collect additional information about how people feel. Again, if British Airways can do it every time I take a flight, I see no reason why we can't do it in terms of justice. We did used to do that, but I think that the kinds of tools that are available now in terms of quickly gaining some information that would enable us to actually do something that would change the experience of people and make it better, we can do that. So I'd like to see a timeline. I'd like to see a commitment. I'd like to see a working group that says, we're going to take this forward. This is how we're going to do it. Because I know in terms of data first, that program really has enabled now the very creative thinking about linking data, about beginning to learn much more about what government has to offer in terms of information that will enable us to think much more strategically and beneficially for the people who use justice.
Terrific. That's very clear and helpful advice. I'm just going to turn the last bit of time that we have to any questions. I did see one appear, which is a very specific one, which I think Barry has offered to pick up. I'm sorry, I can't see that question anymore on my screen. But Barry, could you remind people what it was, and then go ahead and answer?
Surely. His Honour Judge Graham Robinson, who is a designated civil judge for Sheffield, and a very experienced judge, raises the issue of whether or not, and this was something suggested at the meeting of litigants in personal liaison judges. We have a network of judges throughout the country. A suggestion was made at a meeting yesterday afternoon that there could be a short questionnaire sent to participants after there'd been a remote hearing to try and pick up relevant data, much as is the same way is done GP surgeries, hospital trusts, etc. And I would agree with him entirely that would be sensible. I'd simply observe that we're in the middle of a £1 billion reform project, and if there is a focus upon what I could describe as the user experience rather than the end result of a case, then this could, I am sure, easily be done. It's just a question of resources. We have the ability to do it. It's whether we have the will.
Barry, thanks. Natalie, did you want to come back in? Could we move all the presenters back to the stage, please? Thanks. Natalie, you wanted to come in?
That was, I know, proposed to HMCTS in March as a thing that could be adopted. And I think one of the issues that we have with, and this is why getting the data right is so important, is not holding on record in a centralised way data about all those people who have participated in remote hearings. Now, of course, court centre level, you could send out a questionnaire to people who participated in hearings. But one of the issues with that would be, I suppose, response rate, getting people to respond. So say if you're a litigant in person who there are specific challenges with reaching kind of people who've traditionally been described as hard to reach within the justice system. But all of this requires sort of structuring the underlying data architecture in a way that enables you to do things like send out follow-up questionnaires to people at scale, or to be able to identify litigants in person from different backgrounds and then select a representative sample of them so you can be confident that your results are accurate across that group. It's that sort of, it's the absence of the kind of really routine basic information, like how many remote hearings took place, who were the people involved in those hearings, which were the judges, where did they happen, that really hampers your ability to use like research in that way to get good, robust findings. And I think that's why it's so important that we see sort of urgent action to address these really basic and fundamental things, because they act as barriers even to doing really simple, quick things that could really help to bring the voice of people into the justice system.
Terrific. As we sort of come to a close, I'm trying to keep an eye on the Q&As. Adafi or Professor Stanko, did you have any other reflections that you'd like to share as we come to a close? Adafi, would you like to go first?
Thank you. I think I'm going to refer to what everybody else has said on this panel, is that it's about the will. It's the will to do this, the will to, if COVID has shown us anything, it's that a lot of the reasons that we put forward previously were excuses. You know, if we can turn around a vaccine in 9 months, I'm pretty sure we can support the transformation of the court system effectively. But we need to do that effectively and not walk blindly into what seems like a simple solution and ends up being yet another cautionary tale from the National Audit Office.
And Professor Stanko.
Is that without harnessing the hundreds of scientists and social scientists across the country and the globe, we would not have been able to know a lot about, you know, who was COVID affecting. You know, it was a differential population. COVID is not equal, and it is that kind of sense that vulnerabilities do find themselves and they do manifest themselves and they stack. So the one thing I would also say is enable this information to be used by the wider academic audience, because you need to trust people to also be able to find things for you without relying totally on the people internal to the system. And it's that dialogue about how to move justice forward equally that is something that really needs to be built as well.
Lovely. That's terrific. I'm conscious of time. I'm also conscious of whether or not the Q&A has quite worked. Apologies if you've posted things which I haven't been able to see. Just enjoying to close, and I think there were some very powerful encouragements there, as well as practical examples of what we're trying to do here is not about doing something that is unusual, but it definitely is urgent. I'd echo the call for a proper, fully funded timetable delivery plan. Now, Natalie in her digital justice report used this phrase about reform being a window of opportunity to do this. You know, we've heard today the urgency, the opportunity. We have to make sure that window of opportunity does not close. Thank you very much to all of our speakers who've given us terrific insight into these questions and also passion and commitment. And thank you to everybody who's been in the session. I hope you enjoy the rest of the day. Thanks. Handing back to Robin.
Matthew and everyone on that panel, thank you very much indeed. I know I will be forgiven, even encouraged by the rest of the panel if I express particular thanks from the Civil Justice Council to Edafe and to Betsy, that this the kind of insight that you've been able to give to us all across the civil justice sector is invaluable. Thank you. Earlier, we were not able to bring in, because of a technical problem, Robert Hanna, who is the managing director of Augusta, one of the lead litigation funders. Robert and Augusta have been working heavily behind the scenes alongside the Commercial Litigators Forum and the Association of General Counsel of our most powerful companies. Their support has underpinned the National Pro Bono Centre, which itself serves a number of the charities involved in delivery of pro bono access to justice. The question that I was going to put, and I now put to Robert, is why does Augusta support access to justice for those without means? Robert.
Robin, good afternoon, and thank you very much. Can I first of all apologise for not being an IT engineer and instead, as you say, just being one of the founders of Augusta, which is a traditional third-party litigation funder. Over the last 10 years actually, we have reviewed over 10,000 commercial claims, and we look to use our shareholders' capital to pay for the claimant's costs of litigation. If the claim is successful, we make money for our shareholders, and if the claim is not successful, we lose it. It's not surprising, therefore, that we're reasonably selective with the cases we decide to fund. Now, part of our selection criteria is, does the dispute have strong legal merits? Fair enough question, you might ask. Another is, does the defendant have the money to pay us if we are successful? And a further criteria we use is, does the case make financial sense for the claimant? To determine this, we have a rough rule of thumb, which is that the realistic expected damages should be at least 8 times the expected costs. This, we think, should ensure that the claimant receives at least 50% of any award. The problem is that despite lawyers charging what I'm sure they would say are very reasonable fees, 8 times that number turns into quite a large number. As a result, many cases are not financially viable and hence are rejected by us. And unfortunately, this includes cases with strong moral or ethical merits. And even for commercially focused funders, such as ourselves, is very frustrating, to say the least. I suppose this is a long-winded way of saying that when Robin suggested that we may be able to act as a very modest sponsor of the CLF, we were only too eager and proud to accept. And I do hope we'll be able to assist him and his vital good work for many years to come.
Robert, thank you very much indeed. We're now going to break for lunch. Can I just say a couple of things? Because lunch does not mean downing tools or activity. There will be an open video call for general chat and networking available. Please do not hesitate to participate in that. In addition, the networking facility, which will put people into smaller groups, is available over the lunch period. You've got those 2 channels, therefore, for participation. And please make the most of it if you are able to. But let's also look forward to reconvening at 1:15. We will hear then Sir Geoffrey Voss, the incoming Master of the Rolls and Head of Civil Justice. Whilst the lunch period is happening, please don't come out of the system as a whole. If you're not taking part either in the virtual rooms or the meeting hub tool, then please just leave your microphone off and your camera off, but be back with us at 1:15. Thank you again to everyone for really making it work so far. I know we've had a number of technical issues. Everybody has been completely wonderful about that. That's the spirit. Thank you very much.